morning again, week 7 of corporate law and regulation. These slides are on Blackboard, and today we will do a sort of refreshment after the season's holiday break recap, and we zoom in on theme number 5 on workers. And that's the menu of today. Upcoming Thursday, the second round of student presentations will take place, and then upcoming Tuesday at the same time and place as today, our guest lecturer Louise Wietepil will discuss topic number 6, corporate social responsibility, the last topic, which also be or will be included in the exam. So that's not a sort of dessert, but it's the main course. So don't get it wrong. Let's move to the recap, and we have focused on the 5 core characteristics so far, and we mentioned, they're all known: legal person, investor ownership, delegated management, limited liability, transferability of shares. So that is what we discussed so far at length, up to and including the order of mentioning those 5, where there is a certain logic, and that already discloses on exams and work pitches that you have a sort of logical take on it. And we mentioned, and today we will discuss, 4 additional aspects or domains or principles of corporate law. And those 4 additional domains are an attempt to classify, to order all the other topics. So this is pretended and presented as an all-inclusive package. So the 5 plus 4 are covering all the legal affairs concerning a enterprise, undertaking, firm, business, and equivalent synonyms. And those 4 are the assets and finance, workers and innovation, production and sales, and regulation and compliance. So whatever you do within the enterprise can be covered in one of those 4 additional domains, if not covered by the 5 core characteristics. So this is just an attempt to order your folder system on your hard disk, to store knowledge, to have 5 telephone numbers with 5 legal professionals specialized in those 4 domains when there is a problem, or equivalent practical purposes. And obviously you can debate such a taxonomy, such a categorizing, because you can make it 5 or 3 or 6 or 7, and that is up to debate. This is a average clustering. And why would clustering matter? Because the legal professionals you deal with, they portray the law as so specialized that there are 600 domains, and each of them requiring a high-speed professional charging you with $600 an hour, and then doing the hocus pocus and making your life as an entrepreneur miserable. Or if you work together in a enterprise, one of the frames of this course was how to survive a legal colleague in your future career. When they then start addressing the need for specialists, and then you can go back to this thinking and say, okay, let's give me a break. We need to deal with this before Monday morning 9 o'clock, and it should not cost more than $500. So how can I manage that flow of knowledge and those ideas around? That is the purpose. So, and we discussed the first already, assets and finance, and we hinted on it through all those references to the balance sheet. So whatever enterprise you are in, on the left side of the balance sheet, there should be some form of assets, at least yourself. If you're a sole proprietorship rendering services, then you're the asset yourself. And based on accounting rules, you're not allowed to put a human being on the left side of the balance sheet, but hypothetically speaking, that's what you're basically doing. And the key question is, how do I get those assets financed? When you yourself are the asset, you are, as we speak, in the process of financing yourself, you know, with loans and jobs on the side and all kinds of stuff. So that's sort of pre-financing. But real enterprises don't believe in fairy tales and pre-financing. Someone needs to pay for it. And then we touched upon the two main flavors, equity finance and debt finance. Equity finance is at the heart of corporate law, at the heart of responsibilities of shareholders to pay up their share capital. We touched upon attempts of jurisdictions to dream of minimum capital requirements and these types of stories. In the meantime, a little bit abandoned by most jurisdictions. And the debt finance, triggering the whole story of creditor protection, this agency principal problem, that the firm is the agent and the bank is the principal, in the sense that it is the bank's money within the firm in this subtopic debt finance, and that ideally the agent is taking care of the sum of money financed by the bank. This is sort of corporate law Kraakman analysis. A down-to-earth legal professional would say that is contract law, it's called a loan agreement, and there are two obligations: one, repay the money; two, on a yearly basis or monthly basis, pay the interest. And so a legal professional has less emotions about debt financing. They say, so it's a contract called debt or loan contract, and easy, you know, just repay and pay the interest. But theorizing on it in terms of domains, it's the story of asset and finance. And then obviously, there's a lot to say about the types of assets. And today we will touch upon one type more, being trademarks. That is just one of those assets. But think of the buildings, think of the machines, raw material, etc., etc., etc. Very important, and potentially under getting under attention in courses of law and economics. The second domain, and you see that I continued counting, and this is not the right order, but today is about the workers, so I put this in prior to the main theme of today, just to warm up. And production and sales is the whole process of running a business. So, hypothetically speaking, if you take it in these domains, you first arrange those assets, then you have a non-functioning enterprise on a piece of land with machinery and buildings, etc. And then you start, on a daily basis, produce goods and services and sell them. If there's anything important in undertakings, it's this domain. Because buildings, they do not create turnover. Just product services creates turnover. That's the lifebelt, that's the essence of undertakings. And this is the whole range of contracting from a private law perspective, contracting around raw material, employees, sales contracts, etc., etc. And we mentioned one of those themes that is of concern for legal professionals, that is called product liability. This is the course of Michael Mila and consumer protection and all these other regulatory frameworks around products and services and consumers and the like. And just to to mention or to just to give an example what type of legal theme is within this domain, I mention here the product liability. And that is a EU and partly USA, Japanese type of concept where there is a strict liability, so not a fault liability but a strict liability. So even if it was not your intention to have exploding batteries or phones or etc., just based on the law, a additional liability of the producer for any damage caused by the product. A sort of quick and dirty rule within the legal frameworks, and in the Netherlands, just to highlight some quick and dirty business law rules, it's Article 185 of the Book 6 of the Dutch Civil Code, stating that the producer is liable for damage caused by defect in his products unless he proves all kinds of elements that you need to test as a legal professional prior to conclude that the liability is indeed given, but just to highlight one of those critical rules. And as with all the other legal rules, the sheer existence of such a rule determines the managerial course of action on the work floor. So all the efforts to organize an efficient organization with checks and balances and quality control and training of employees, etc., etc., are not there because undertakings, just to give you a black and white picture, they are not there just or because of entrepreneurs are loving their employees and loving their customers. They do not. They just want employees to work hard and customers to buy the products and shut up. That is black and white speaking, how deep down the emotion of entrepreneurs are. And one of the theories of legal professionals is that they say, well, given our legal rules, they behave. They arrange their work practices in such a way that there is no liability at the end. So that is a typical jurist way of thinking. In School of Economics and in business schools, you have a more positive view on entrepreneurs, where it is put in your DNA to take care of your employees and your customers and the environment and Mother Earth, etc. And from that perspective, these rules are just there to be a sort of control mechanism for the rogue entrepreneurs. You know, those bad guys. Not us, but the bad guys. And so here are some remarks you could label as sociology of law, maybe even. These sort of, or psychology of law, sort of framing of what are these functions of these rules. Maybe it is not necessary to dwell on the function of the rules. They are there. And you have to deal with them, and these are these functions. Today, we move to the third domain, and that is workers and innovation. And the last domain we will touch upon in the last 5 minutes of today. So we move to the topic of today, the workers, and that is this theme around sort of two aspects. One is the workers as in producing the goods and services, but maybe on a timeline, workers are primarily responsible for inventing the product in the first place. Otherwise, there's no problem. So what I like to connect is that all the products we use on the globe and services are invented by humans, not by legal persons or by, you know, entrepreneurs other than human being entrepreneur. The most striking example are artists, because they make the songs, then they perform the songs or record the songs, and you buy them on Spotify and Apple Music and etc. And there you have a beautiful union between the human being producing, innovating the product or service, and then producing it. In larger enterprises, there's a specialization of human beings, and certain human beings are tasked to do the innovation, also called research and development, R&D, or many other names, and others are tasked with making it. And then the next step is that you put in geography, that you say, well, the inventors are in Silicon Valley and the producing workers are in China. And these types of specialization aspects at the core sometimes of certain courses in your School of Economics. How you efficiently can get the best out of it. And then the theme of innovation links back to the assets, because you can solidify or freeze the innovation in certain intellectual property rights. Copyright, trademark, patent. And that is a trick of legal system to forbid competitors to use that innovation. That's the whole thing. And that is regarded by legal professionals as an asset theme. Let's move to the workers and let's connect it to this course. On page 89 and 90 and 91 and 92, there are some comments from the corporate law perspective on workers. That's one. Two, we will add today some examples of the labor law perspective on workers. And those are two sort of fields of law represented by specific legal professionals who are in different legal practices. And legal practices were defined in week 1 as the environment in which legal professionals operate. And one of those indicators of that environment is the theme, the interest they represent. And when you look at corporate law, the interest represented there is the interest of the enterprise, so that is top down. That is the worker as robot, and how can we make them work efficiently and that they shut up. That perspective, that is the atmosphere interest of corporate law, jurists. And labor law is the opposing party. That is a law firm at the corner of the street where a disappointed worker, employee, can knock on the door and say, my employer is treating me not nice, can you help me to fight my employer? Or lines of that nature. Which is, as first step, good to realize. Then, like with my comments on entrepreneurs just 5 minutes ago, those professionals and entrepreneurs portray their actions as out of one soul. No, we all care about the employees, and there's no difference between a corporate law and corporate lawyer's perspective to employees and a labor law jurist perspective on employees. And so if you talk to people in the field on birthday parties and recruitment fairs, they don't make this distinction, because that is, we are all happy and we assist each other. But when you look at it, as I do as practicing lawyer, from the courtroom, there's no harmony, I can tell you. And then it's better to realize, let's first assume we are not friends, and maybe it's not as bad as I think, rather than the other way around. Just to phrase or to give some context also for the terminology corporate law and labor law. So, in terms of corporate law, the second distinction we need to make is that we have human beings that are appointed as board member, which is one of the 5 core characteristics, delegated management, which is a human being and which, by definition of law, is also an employee. Because he's running around in an enterprise, and all the human beings running around in an enterprise are called an employee. But corporate law treats board members, with all the synonyms, as special employees. Think of no rights employees. Remember, the shareholder can dismiss the board member 24/7. But it's still an employee. So that's one. The other one is all the others. All the other human beings are regular employees. So that is an important distinction to appreciate the theories of Mr. Kraakman and his team on the corporate law take on employees. Well, and then leading questions. What is then the problem with those workers? Where are the principals and agents? So one exam question will be on workers. And then in your mini essay, you, in the preliminary remarks, you mentioned, well, he or she is the principal and he or she is the agent. To give a insight in that framework. And then last question, what regulatory strategies are applied? I repeat, regulatory strategies is a theoretical phrase pointing at states, pointing at jurisdictions, so not at corporations and not at human beings, but at the machinery, the kitchen of law making, parliaments, governments, who are making arrangements, ex ante, ex post, to create a jurisdiction in which the agency principle problem is solved. So in a few papers, just to give some feedback on that already, I saw that a undertaking was adopting a regulatory strategy. And that is technically not the way these scholars used the phrase. The beauty of words is that there's no word police. So if you reason why a undertaking adopts a regulatory strategy, that is scholarly wise okay, because it's just words, and if you define then what you meant, it could be well a meaningful phrase. But just to not extend the interpretation too much, ideally on the exam at least, it's nice when you link regulatory strategies with states. In this topic, we have, in the broad sense, 2 strategies. One is called labor law and one is called corporate law, and we will deal with them one by one. Let's start with the corporate law regulatory strategies around employees. So the top-down idea. And then we start with the problem, with the agent problem. And one of the agency problems mentioned on page 89 is that to work for a specific enterprise, you need to invest as a human being. You need to learn the tricks of that enterprise, the house rules. You learn how to make iPads for Apple, and you have all kinds of trainings, or the ways KPMG is dealing with clients, etc. And based on intellectual property rights and other house rules, it could be the case that you're not able to use those skills outside that enterprise. Because that enterprise is the only enterprise doing it. Apple's the only one making iPads. So if you're a star in making iPads or designing iPads, you cannot move to Samsung because they have a different software, and if you have some ideas, good ideas from Apple, you're not allowed to apply them at Samsung, who make tablets too, but not iPads. And that phenomena is called to be locked up or to be holed up. So when you choose for a certain enterprise, you, like in a old-fashioned Western concept of marriage, you marry to your employer and you're not allowed to play outside. Which, from a corporate law perspective, from a corporate theoretical perspective, causes a agent-principal problem. Because employers take advantage of those employees being locked up. And taking advantage is not a criminal activity or a deliberate attempt to make the life miserable of an employee. No, economics call it supply and demand. And because of that sort of negotiation phenomena of supply and demand, employers can take two concrete advantages of such an innovation or a situation. One is reducing salary, and two, reducing work circumstances. And we in the West believe that there is no such thing as conditions going down. We believe that workers' conditions are always going up, salaries are going up, and work conditions are going up. That's not the case. Look at the newspapers, at protesting nurses, police, persons, all kinds of others, who did not get a inflation correction in their salaries for sometimes 8 years. You're familiar with the concept of inflation. That means that the next year products and costs are 2% more expensive, relatively speaking. If your salary is not adjusted, then it is relatively speaking reduced by 2%. So we are so spoiled that I need to make this very explicit. And let's not start talking about work conditions, because that is the things you actually discuss at work fairs. Do I really have to work 60 hours at KPMG, Ernst & Young, etc. per week? And that's work conditions. And they say, no, it's 40 hours. And then at your first job, it's okay, you did your 40 hours, but the client expects this tomorrow morning, Saturday. Could you stay and skip the Friday afternoon drink, etc. And so that is work condition. Or one of my favorite nagging stories, the difference between pay between men and women for the same job. Ladies, don't accept it. Boys, don't make use of it. And this is one of many themes in our world where work conditions are an issue. So you don't need to talk about the conditions of miners in Congo, you know, those children mining our substances that are in our batteries and these types of stories. We don't need to go there to discuss workers' conditions and pay. So that is the problem. And then like with all the other agency problems in corporate law, there are attempts to solve them with regulatory strategy. And then two are most popular, or one is very popular, with jurists at least, because they understand them at best, and that are rules strategies. As in, rules pertaining to salaries, for instance. To dwell on that example, most states have either minimum wage legislation or, like in the United States of America, very powerful union legislation in which the workers' unions negotiate minimum wages for certain sectors. So most sectors in the United States, mining, car making, hospitality, hotels, are having sort of collective agreements with a minimum wage. In the newspaper and in our ID, when we think of the United States of America, there is no such thing as minimum wage because they have a crazy labor system, we think. But when you look at it in most relevant sectors, there is a certain regulatory strategy in a certain way to get this end result that a agent, the corporation, is not allowed to take advantage of the locked up situation of an employee in the area of salary by going beneath a certain threshold. Just as a example. What other strategies are used in corporate law for this agency problem? And by the way, the corporation is the agent and the locked up worker is the principal in this relationship. Where you had another agency problem that the corporation is the principal and the worker is the agent. When it comes to the worker representing the interest of the corporation outside, the cashier, who is not allowed to give her neighbors a free ride because she's the agent of the corporation and not allowed to misinterpret the interest of the corporation. Here it is the other way around. The other way around. Underlining the importance to be precise when you point at who's the agent, who's the corporation, because that is not a fixed definition. That depends on the topic of the week. 5 core characteristics, 4 additional domains. And that's the function of this taxonomy. Well, what are the solutions? And then many jurisdictions embrace the strategy of appointment rights. And this is the topic from a corporate law perspective where employees are appointed as board members. The most extreme jurisdiction is Germany, the Federal Republic of Germany, in which, where it comes to the supervisory board for huge multinational enterprises, 50% of the supervisory board members should be appointed by employees. So let's take these steps once more. Employees have a problem. They're locked up. They can be maltreated in terms of salary circumstances. They're the principal, the corporation is the agent, should take care of that if you make moves as a state. Zooming in on appointment rights. Appointment rights are the rights of shareholders to appoint the board. Core characteristics. 5 pieces. Number 3. And appointment rights can be tweaked in corporate law. As in, shareholders appoint or with many jurisdictions, if you implement a supervisory board, then you delegate the authority of appointing board members from the shareholders to the supervisory board. And then the supervisory board is appointing the executive board members. On that theme, this jumps in, that there's an additional deviation from that pattern, that it's not only the shareholders who appoint supervisory board, but by law, regulatory strategy, employees. That means, in concrete terms, in the infamous general meeting of shareholders, there are shareholders, you know, you and me, institutional investors, BlackRock, these guys, and employees, who then have proposed on the agenda, remember the importance of agendas, of the shareholder meeting, the appointment of Mr. X, Y, Z, who are to their liking. And the thinking behind this regulatory strategy is that if we have 50% shareholder bench appointed supervisory board members, and employee bench, employee appointed supervisory board members, that the body of supervisory board members, who then appoints executive board members, make the perfect choice in terms of those executive board members, who then will not take advantage of the locked up situation of the employee. So remember that these strategies result in behavior of actors around the corporation, but are a quite indirect attempt to solve the problem. Because yes, you have 12 supervisory board members, 6 appointed by the employees and 6 by shareholder, but they're just human beings, you know? And then if Volkswagen has difficult times, and then any sensible executive board member is not raising salaries, because otherwise we go bankrupt. And so appointing employee-friendly people is no guarantee that they can give you paradise. Because economics is, you know, a fierce battle, and not dictated by agency problems, but dictated by products and services and customers. And when they buy it, it's okay. When they're not buying it, it's not okay. As simple as that. So, remember, we talk about strategies that are indirectly effective. That is not mentioned that much in the book. It's almost presented as solved, tick. But remember, those appointed human beings are just human beings, maybe with a MBA. And they have a sort of feeling of, you know, offer and demand, and supply and demand, etc. That's their point, right? There are jurisdictions that don't even think to go there. Japan, United States of America, UK. In the battle between jurisdictions, if certain jurisdictions adopt these types of strategies, other jurisdictions say, don't do that. Trying to attract corporations for the most favorable jurisdiction. And then we have halfway jurisdictions, like France, where they say, okay, 1/3 is appointed by employees. Or the Netherlands, who has a sort of, well, some are appointed by employees, if you wish, and words of that nature. Obviously, an individual corporation can create articles of incorporation in their own capacity, adopting these rules. So a corporation in Delaware is more than authorized to make articles of incorporation with these elements included. and then a hardcore United States of America, State of Delaware corporation is just as employer friendly as a German Aktiengesellschaft. And this is what I like to stress in a global economy. So the fact that there are differences between jurisdictions does not mean, and I even dare to say, quite often you're not even allowed to make use of these arrangements. Think of taxation. Because the general emotion in the public is then all of a sudden as a boomerang hitting you. And we experience that with taxation, with child labor, with spoiling oil in environment and these types of things. And why not in terms of employee representation in boards? So thinking as a Greta Thunberg, everything is possible in terms of the design of corporation. Remember, if a legal profession says, well, in Delaware, we do not have employee representation in the board. That statement means, in the law, it is not required. But the law does not say that it is forbidden. You see the nuance? And lawyers think in terms of, if it is not obliged, then don't do it. Which is quite curious thinking. And next week, with corporate social responsibility, we meet a domain where all of a sudden that's not a valid thinking. If it is not forbidden, you're allowed to do it. No, no, no. You still have to continue to think and ask yourself, okay, do I want it? Etc. Just to highlight a sort of debate among jurists, because the books say Germany is doing it like this, Delaware is doing it like this, end of story. Which is straight. Appointment right. Then, and just a note, these arrangements, these strategies are on top of labor law. So it's an and. So it's not or, but all kinds of solutions and strategies on top of each other. Which makes it complicated, which jurists like, because then we can sell hours to solve misunderstandings, etc. Decision rights. Decision rights are less treated by corporate law, because appointing employee-friendly board members was sort of the last station. Corporate law has difficulty in sort of taking the next step and saying, well, and then you need to make certain decisions. Why is corporate law hesitant? Because there are trillion types of decisions and no one can say in advance which one is the best. Remember the task of board members and their personal liability. Core characteristic. There's no personal liability, limited liability, unless you step outside the average man, the average board member behavior. Fiduciary duties. And that's the only realm where corporate law connects decision rights to employees. By stating that the responsibility of the board is not just profit, but also people and planet. So that it is a defendable board decision in the light of scrutiny by shareholders. To take care of stakeholders is a quite often used word. And part of the stakeholders are employees. So that is vaguely in terms of decision rights, but that is the standard strategy, because standards was exposed, so that the behavior of the board member is tested, scrutinized, exposed in the hypothetical bankruptcy situation where there is a shortage in the estate and that you then sue the former board member for his decisions And then, if a decision was aimed at employees, and then resulting in bankruptcy, that is then part of a reasonable interpretation of your task as manager. So that is sort of the maximum corporate law dares to go. But then we move to labor law, and there we have the title, the theme, co-determination. Co-determination as in the rule in most jurisdictions that a enterprise may or should have a workers' council. Think of your own student council. A additional organ within the enterprise, on top of the board as an organ, the shareholder meeting as an organ. You have the workers' council as an organ. Why is that regulatory strategy? Because in labor law it says, if you, in the Netherlands for instance, if you have more than 50 employees, you must have a workers' council. So you're breaking the law if you're not having a workers' council. And workers' council are a headache, because your employees are, during work time, discussing workers' council stuff and not producing goods and services. So that's a loss. And then, that is chapter 2. Chapter 2 is the rights of that workers' council. And then the dream of labor law is that workers' councils may decide on certain things. And there's no jurisdiction basically that goes that far. So what are the rights up to deciding? 2 elements. 1, the obligation of the enterprise to provide information to the workers' council, as in information is power. And 2, that labor law, co-determination law, says that the workers' council should be allowed and provided with facilities to provide advice to the board. And the third flavor is design. But that is not included in most jurisdictions. So if you think of any decision process, then it starts with information, then it starts with advising specialists who advise you, or employees with a certain portfolio, they advise you, and then you make a decision. That's sort of the X-ray of any decision of a board. And when you look at labor law, subsection co-determination law, and then zoom in on what are then the rights of such a work council, then the concrete items are that they receive information and that they should be allowed to provide advice. And then such a regulatory framework, legal framework, adds a sort of little sanction in such a framework to make it sort of serious. And not this sort of, oh, I like employees, here's some information, but I have already decided. And that tool is that by law, in the Netherlands, in Germany, and a few other countries, such a board decision is invalid until the information is provided and advice is received. And that is quite annoying if you have to meet a initial public offering deadline, you know, trademark 1st of December, and then when you forgot the Workers' Council, you cannot sound the bell at the trademark if that was the decision you needed to make. Okay, and then obviously there is a restrictive list of topics where such a rule applies. Because there are many decisions that do not affect employees. So the lists in these laws that define around which topic this is the procedure includes the salaries the work conditions, amount of hours, substantial changes of the operation. Think of, we close the video production part of Philips, because no one buys videos anymore, you know, those huge thingies, grandpas telling stories. You know what a video is? It's sort of huge thing, okay? You're still not that young that you don't know that. And if you make such a decision, let's close that part of the enterprise, that affects employees in the sense that it's most likely that you lose your job because of that decision. And so major transformation, which was one of the themes of categories of things we discussed in corporate law. And so major transformation is one of those topics where the Workers' Council is then entitled to information and the right to provide advice. And then there's a half additional 2.5 flavor, and that is called consent. And that is halfway between advice and deciding. And consent, in a highly limited amount of topics, for instance, the facilities of the Work Council itself, you know, how much money they may spend on lawyers to advise them and stuff like that. There's a sort of consent, and that is that the board decides. Remember, the board is the only organ in any enterprise that makes decisions, because all the other employees are just robots, don't tell them, in terms of decision right. So the decision is made by the board, because that's the only organ that makes decisions, and it's only valid when it is sent to the Workers' Council, who then say, okay. So that's sort of double loop. Information, advice, decision, and then consent. Because the decision is sent back to the Workers' Council. This is what we made of it. Are you okay? And then they have to send their consent. How is this sort of proven? By a paper trail. So in the decision file, there should be the email asking or providing information. And then in the information file, there should be this email or letter asking for advice. And then the third folder is the received advice. And this is what most likely you will do in 15 months. Organizing hard disks with, that's proof that these decision trajectories are done properly, you know. With the ultimate consequence that your decision is invalid, you know. You're merging Bayer, Monsanto, and you forget the Workers' Council, that would be a drama, you know. Multi-billion loss because of some guys in Venlo who saying, well, but we disagree, or whatever. And don't underestimate this thing. And then obviously, mentioned on the slide, if the enterprise still continues such a invalid decision, you can go to CORP. And another part of labor law says that members of a work council cannot be dismissed easily, because that's the first thing you want to do as an enterprise. When the Workers' Council drags you to court, then dismiss those workers. They're the enemy. I don't want paid salary to my enemy. No, labor law says they're protected. So that's a quite interesting dynamic where sort of in labor law there is a arrangement designed that directly influences the core procedures of a corporation from a corporate law perspective. Let's have a break and then move to the remaining topics of today after the break. 11 minutes. See you in a bit.